And there we go. So welcome, everybody. I am Allie Jackson, and I'm with Centennial Escrow. And you are here on Marketing Mondays. And normally Marketing Mondays is very focused on real estate marketing. Today, with a very topical discussion, we're sort of expanding the theme. So it's really Educational Monday might be a better fit for it. But just before we jump into all of that, I just, again, want to thank you for joining us. I'm with Centennial Escrow in Southern California. True independent escrow company. I have an incredible team of very experienced escrow officers, including bilingual certified senior escrow officers, so we can take care of all your residential escrow needs. And I have a background in marketing, so always happy to sit down, have a one-on-one, a Zoom call, what have you, with you to talk about your marketing needs, because it's more than just getting an escrow closed. I'm here to help you get more. So with that, I just am very, very excited to introduce our speaker today, Saul Klein. Saul is president of SDMLS. He is the father of technology and internet adoption for the residential real estate industry, generally recognized within the industry as a technology pioneer and its first internet evangelist. Saul created one of the first online real estate communities, Real Talk, and developed it for the National Association of Realtors in '95, and it's still an active community. He was one of the original members of the first Realtor.com team, where he was a driving force in the migration of listings from the MLS book to the internet. Saul introduced the real estate industry to internet and email listings on the www online education and listing data syndication. He's one of the few visionaries who paved the way for real estate transition into technology. And that is just the precursor. I could go on the entire half hour to talk about all the recognitions and awards about Saul, and I'm sure many of you who know him well, who are on this Zoom today, could as well. But instead, I'm going to lob it on over to Saul and ask him to talk a little bit about what today's topic is, which is very timely. And those are the ramifications of these NAR lawsuits and a little bit of background information about the suits. So with that, thank you for joining us today, Saul Klein.
Thanks, Allison. Thanks, everybody, for listening in. There's lots to talk about, so I'll say that when we're done, you can feel free to reach out. I think we've got a handout. You can have a copy of the notes. This is an ever-changing situation. And so we're going to talk about the antitrust lawsuits. There's more every day, but I'll talk specifically about 4 of them for you and give you some background. And the subject is there's an opportunity here, and the opportunity is everybody's heard about this, and because everybody's heard about this, they're going to have questions about it. And so it behooves you to know about it, to be able to talk to customers, buyers, and sellers about this, to be knowledgeable. It'll help you build trust and confidence in relationships, and it's important that you just keep doing things pretty much the way you're doing it, with a couple of small exceptions, and wait for this to kind of shake out. But it is big news. It's got the potential to dramatically change the way people do business in real estate. We don't know exactly when or how, but it's better to be prepared. I always say it's better to see the cliff well in advance. And so as we go through this today, I think we'll be able to give you some insight into exactly what's taking place. So you heard about probably this case in Missouri, Sitzer Burnett versus the National Association of Realtors and major franchisors. And so it was a big case, and the decision was a judgment where the damages were approximately $1.78 billion. And because it's an antitrust case, they're tripled, and that makes the damages about $5 billion. And that's a huge amount of money. And so that's against the National Association of Realtors, against Keller Williams, against Anywhere, which is the old Realogy, against, I think, Home Services of America, these major companies, $5 billion. So that's one suit. And that's the one everybody's heard about. That's all the buzz. And I just wanted to kind of get that out of the way, and we'll come back to that. And what we're really talking about are 3 civil lawsuits. And that's the first point, is that we're talking about civil litigation. Now, there's also one that's the Department of Justice against the National Association of Realtors. And that's a huge case, but that's not the one that's getting everybody's attention right now. The ones that are getting everybody's attention are these civil suits, and they are antitrust lawsuits, and they're class action. So important points: class action, civil litigation, possibility of triple damages. The first one has already been to trial, and we went over the judgment. $1.78 billion tripled to 5. There's a bigger case. So the big case was really Merrill, Moehlr, and I'm going to keep repeating these things because I think it's important that you be able to talk about it, because there's not really that much. It's really very much a funnel, right? A tunnel. So if we got the basics, and as things get added to it, it'll be real easy to add on to it. So 3 lawsuits, civil litigation, antitrust, and they are Merrill, that's in Illinois. And what's being attacked is the offer of compensation in the MLS. So it's important to understand MLS. And so there are a number of different ways to formulate multiple listing services, and most of them are formulated and act under the guidance of something called the National Association of Realtors MLS Handbook. Now, the National Association of Realtors, and this is very important, does not have an MLS. Doesn't have an MLS. But the National Association of Realtors kind of like has created best practices for multiple listing services. And if you are a realtor-owned MLS and you follow the best practices, the MLS handbook, which, by the way, is available to you if you're a realtor, you can go to nar.realtor and log in, and you can download a copy of the MLS handbook and learn about and read about MLSs. And that's important because the MLS is probably your most important tool when you sell residential real estate. And so the National Association of Realtors has these rules. And if you follow these rules, then you're covered. Your MLS is covered by the errors and omission insurance of the National Association of Realtors. So, of course, just about all realtor MLSs, which are typically owned by local associations of realtors, or they are regional, owned by a number of local associations of realtors. There are also broker-owned MLSs. And MLSs function typically as either a committee of their association, or as a wholly owned subsidiary, or as a regional. And again, if they're realtor MLSs, then they follow this guideline of the National Association of Realtors. And so every one of the things that makes MLS work is that there is what I refer to as a compensation vehicle. So MLS has a compensation vehicle. And I was first licensed to sell real estate in 1975 in California, got a broker's license in 1977. And I joined the MLS, and the compensation vehicle in the MLS, and some of you might remember this, was a unilateral offer of subagency. A unilateral, I won't ask you to raise your hands, but I can tell that some of you remember this, right? That the MLS was a unilateral offer of subagency. And what that meant, and we didn't always know why, but what it meant was everybody represented the seller. Everybody represented the seller. And so if you took a listing and you put it into the MLS, all of the other participants and subscribers of the MLS, they could represent the seller as you represented the seller. They were really subagents. And so the compensation was easily flowed because the compensation vehicle was this offer of subagency. Everybody represented the seller. There was no beef about the seller paying the commission to both parties because both parties represented the seller. And that was the unilateral offer of subagency. And that worked. Now, here's the deal. We didn't have to tell buyers that they weren't represented. So we all represented the seller. There was no law that said we had to explain to sellers or buyers that we represented the seller. We were cautioned not to call buyers clients. Our attorneys said, no, you call your buyers customers, call your sellers clients. And the reason they were clients is you had a fiduciary duty to them. Everybody represented the seller. Well, the Federal Trade Commission in 1983, and this is an important document if you haven't seen it to read, it's on the internet in a number of places. You can find it on our website on the dataadvocate.com under resources. And it is a 1983 study of the residential real estate industry. And it kind of laid out a number of things. And one of them was that buyers weren't represented and didn't even know they weren't represented. And so there was a movement to inform buyers and sellers of representation in real estate transactions. And the first state to pass agency disclosure laws was California. And so we passed agency disclosure in California in 1986. And we had like 15 months to get ready to start to use the forms created by the legislature. Now, you might not know this, but there were actually 3 bills on the floor of the legislature at that time to kind of control agency in real estate. And one of those wanted to make dual agency a criminal offense. And so there was this push to outlaw dual agency. And so what happened was the California Association of Realtors was very active in lobbying the legislature in California at the time. And what we ended up with was a compromise. And the compromise was that you could still practice dual agency, but you had to disclose to a buyer or seller who you represented in a real estate transaction. And that's the case today, isn't it? After you establish more than a casual relationship with a buyer or seller, you got to sign this agency disclosure form. Now, in California, there are 3 ways to represent consumers in a transaction. You can represent the seller exclusively, you can represent the buyer exclusively, or you can represent the seller and the buyer as a dual agent. And you had to make this disclosure, and it's on disclosure forms that are mandated by the legislature. And so in 1988, we all had to start disclosing who we were going to represent in a real estate transaction. Now, remember, the compensation vehicle for an MLS in 1988 was an offer of subagency. And so everybody represented the seller. Now, all of a sudden, we had to make disclosures. We had to say who we represented. Now, if I didn't take the listing and I wasn't paying much attention to this, which is like most agents at the time, if I didn't take the listing, I knew I probably wasn't representing the seller. And I had this form and I had to check the box that said I represent the buyer, or I represent the seller, or I represent them both as dual agency. So what box do you think most people that were working with buyers checked? They checked the box that said they represented the buyer exclusively. But the fact was they didn't represent the buyer exclusively because they were a member of the MLS, which meant they represented the seller. And now they just documented a divided agency. They documented to both sides. They were lying, right? They said, oh, I represent the buyer exclusively, but in fact, they didn't. That's an undisclosed dual agency. It's against the law. And so the structure of MLS was creating legal liability for practitioners. And so we had to do something about it. We had to change the compensation vehicle of MLS. We had to, in California came up with this idea, why don't we make the MLS an offer of compensation? Eliminate this idea of subagency, make it an offer of compensation. And that's what happened in California because NAR wouldn't adopt that. It took the NAR up till 1996 to adopt it. So in about 1991 in California, we created our own MLS model rules, and we changed the compensation vehicle to an offer of compensation. And then NAR in 96 changed their model. Remember that the NAR's got these model rules, this MLS handbook, and NAR changed its model rules to make MLS an offer of compensation. Now, you could go out and represent buyers in real estate transactions because you no longer represented the seller by virtue of your membership in an MLS. And that worked great from 1996 till about 3 years ago. And about 3 years ago, what was challenged in these civil lawsuits was the offer of compensation. And so in all of these cases, what the plaintiffs are saying is that offer of compensation is a violation of the Sherman Antitrust Act. It's forcing us sellers to pay commissions to buyers' agents when we really shouldn't have to do that. And by forcing us to do that, it's holding commissions at a high level. It's a conspiracy. And we think that we need to be paid back for all of that money that was paid to buyers' agents because the offer of compensation is illegal, should be illegal. And so that's the crux of all of these cases. This offer of compensation is being challenged, which, remember, was done to protect consumers and real estate practitioners back in 1996. It was actually a movement, which takes me to another point, that MLSs are evolutionary. Things happen and changes are made to fit the marketplace. And we've always been that way. And I'm an advocate for MLS. And so we always make those changes. And this seemed to be a good change. And it was a good change. And it worked until we had this tremendous hot market where everything was selling. As a matter of fact, all you had to do was put a sign in the ground. You got 20 offers on your property. Most of them were above the listed price, and people were even waiving inspections. And in that case, when it's such a hot market, why do you have to offer, if you're a seller, why would you have to offer 2 or 3 or whatever percent to someone to bring a buyer? All you need to get a buyer is put an ad, get it up on one of these portals, get it up on a portal, or put an ad in the paper or put a sign, or you're going to get plenty of offers. And they're going to be more than you think the property's worth. And yet everybody still is paying buyers commissions, and commissions didn't come down on or buyers agents, and commissions didn't come down on the buyer agent side. So what this did is kind of created evidence for these plaintiffs to come after the real estate industry. And remember, the Department of Justice has been after the real estate industry since before 1983, and the Federal Trade Commission as well. So now what we've got is we've got these 3, really more than that, right? But I'm going to say 3 cases. And those 3 cases are the Missouri case, and that's Sitzer. And that's the one that was $5 billion in damages, which is going to be appealed by the National Association of Realtors. And then the one in Illinois, that's Merrill, M-O-E-H-L-R. And the estimated damages in that case are in the tens of billions of dollars, because they're going back like 4 years. They're saying the commission on the buy side for the last 4 years, everybody that bought real estate in these jurisdictions is going to get money back out of this litigation. There's another case, it's a smaller case, but it's a very telling case. And that's in the New England area. And that case is Noselec. I think it's N-O-S-A-L-E-K, Noselec versus MLS PIN, Property Information Network. Now, that's a private MLS. Nonetheless, they're following NAR rules. And that case was actually settled. A settlement was proposed for where the MLS agreed to pay $3 million to the defendants. And they're the same, the National Association of Realtors and these major franchises, major brokerage firms. And the settlement was for $3 million. The MLS would pay $3 million, and about a half of that would go to the plaintiffs. The other half would go into a legal fund to help the plaintiffs go after the other defendants. And there was also some provisions in that settlement proposal that would indicate that where the listing agent would have to make sure that sellers understood they had no obligation to pay buyers agents. So no obligation to pay buyers agents, and $3 million, and even to certify somehow that the seller understands that they don't have to pay any buyer's agent, And part of that also was there was this myth kind of, and NAR tells me it's a myth, and I'll go along with NAR. There's this myth that the MLS had a rule that said you could offer any commission as long as it was $1 or more. Well, NAR says that's a myth. You could always offer 0. 0 is a number. And there is no policy written anywhere in NAR's guidelines that say you have to offer $1. It says the MLS is an offer of compensation, and NAR always interpreted 0 as being an offer. It's like a 0 offer in my mind. But you never had to offer $1. It was always 0. Now people they're stepping forward and saying, okay, now we have to make sure people understand that it's 0. And in my mind, 0 is no compensation. But the MLS structure still says that the MLS is an offer of compensation, even if that offer is 0. So in the no select case, they agreed. The MLS PIN agreed to say 0. They agreed to make sure the seller knows they didn't have to pay a buyer's agent. They agreed to pay $3 million in damages. And the Department of Justice stepped in, and the Department of Justice is not a party to that litigation. And they stepped in and said, we need 60 days to evaluate this. Wait a minute, you're not a party. The plaintiff and the defendants agreed. Too bad, we are the Department of Justice. We don't like it. Well, if you don't like 0, what are you looking for if you're the Department of Justice? And I'll give you the answer that everybody's afraid to give. They're looking to eliminate the MLS's offer of compensation. You can still have an MLS, but you got 0. In my mind, 0 is no compensation. So if 0 is not good enough, what do they really want? They really want the compensation vehicle to change. And remember, the first compensation vehicle was subagency. The second compensation vehicle was offer of compensation. There will be new ways to compensate buyer broker in the future. And when we get to remedies for you, if you're practicing real estate, you better get used to using buyer agent contracts, buyer broker contracts. You better get used to being able to write the contract to make sure that the compensation comes from the sell side somehow contractually, because we all know the buyers are using all the money they have for down payments and closing costs and other things. And buyers, at least at this point, aren't going to want to pull money out of their pockets to pay somebody who represents them. There actually could be kind of a detrimental effect here where buyers think that they don't need representation, particularly if they had to pay for it. And we go back to the days when buyers didn't really have representation, which is the old model, right? So what's under attack is the offer of compensation as a compensation vehicle for the MLS. What are the 3 cases? Missouri, $5 billion already. That's the Sitzer-Burnett case. Illinois, that's the Merrill case. And New England, Boston, and the surrounds, a big MLS Property Information Network, MLS PIN. Now, as soon as the verdict was handed down in the Sitzer case, which was, I think, October 30th, the lead attorney for the plaintiff filed another case in Missouri that he plans on taking nationwide, and that case is Gibson. So now we have a 4th case. And then I wrote this down the other day because here's some new cases. There's a new case in South Carolina. There's a new case in New York City. These new cases are going to start popping up everywhere. They call them copycat cases. And so you'll start to see more litigation against brokerage firms, the big brokers. Now, I just got back so that's kind of the summary, right? It's 5, now we know there's 5 cases. 4 of them are civil cases. 4 civil cases are class action. Class action, part of that means triple damages. And the damages here are enough to bankrupt all of the companies. And so in this, including the National Association of Realtors if they lose. And so the next step for NAR and for the defendants is appeal. And so that's what we're in, this appeal period. And the appeal, you can't just appeal, you have to post a bond. And so NAR is going to try to scrape together enough money to post $5 billion, a lot of money. And so they're going to put together enough money. NAR says they're going to do it, and I don't doubt them, that they're going to appeal this. And so here's the actions right now for NAR. They're what they call post-trial motions. NAR is going to try to get the decision vacated. That's the first post-trial motion. Vacate the decision. Then the next, if the decision is not vacated, the next one is to ask for a new trial. And if that doesn't work, then they'll go through this appeal process. And the basis for the NAR's appeal are going to be that the jury was not given proper instructions. Now, when you look at antitrust cases, and I'm not an attorney, I'm a real estate broker, but I've been instructing long enough to sink my teeth into these things. And so when we're talking about the antitrust, there are two ways for antitrust cases to be decided. One is per se. And basically what that means is don't even argue about the facts. We're saying that the way you did business is against the law. It just is. And we're just going to determine what the damages are. The other way is called rule of reason. Rule of reason. And if you are able to have the case decided under the rule of reason, then you can bring all kinds of other facts in. And it's not just automatically illegal and a violation of the antitrust laws. And what happened in this case is it looks like the judge said that this is a per se. He asked like 3 questions, right? He asked to the jury, do you think this was a violation of the antitrust laws? And they all said yes. Do you believe there was collusion? They all said yes, right? So they answered these questions, very basic questions, and then it was just a matter of damages. And so the part of the appeal will be based on the wrong instructions. They'll say that wasn't, it should have been a rule of reason and not per se. And then another grounds for the appeal will be that the plaintiffs were the indirect purchasers of the services of the brokers. In other words, that the defendants were not the people offering the service. And it was really one step above. Now, will they be successful? I don't know. We're all waiting for that. But in the meantime, it's important for you to know, because buyers and sellers are going to want to know about this, that there are these now 4 civil cases, and there will be more. And then there's this one big beef that the Department of Justice has against the National Association of Realtors. And they believe that the system has been artificially holding commissions up for years. And they believe that in the rest of the world, where they don't have our system of MLS, which, by the way, the rest of the world loves our system of MLS. They can't figure out quite how to implement it, but they love it. Matter of fact, I'm going to Paris on the 29th of this month to participate in a forum, an MLS forum in Paris, where people from all over Europe and the rest of the world are coming to hear people who understand MLS talk about MLS and how it's made up, and what about the technology, and what about the history, and how can they best go about setting up MLSs in their countries. And yet in this country, we're having a major issue with our compensation vehicle. And in the rest of the world, they pay a lot less in commissions. And so that's what you're confronting today are these 4 cases, 4 civil cases, and then the one big case against NAR by the Department of Justice, which has its own history. And then people always say that, well, what do I do? What do I do now? And I think the best thing you can do is explain to people what's going on. And explain, we've always said you need to explain what value you bring to the transaction. Now you got to continue to do that. You see, prior to this, we didn't really have to sell our benefits to the buyer, because what allowed us to get compensated on the buy side was the fact that somebody took a listing on the sell side. They took a listing on the sell side, they put it in the MLS and the sell side contract, and the MLS made sure anybody that brought in a buyer got paid. And it didn't even matter whether the person that brought in the buyer on the buy side got their license yesterday or 20 years ago, whether they were experienced or not experienced, whether they worked hard in the transaction or didn't work hard in the transaction, they all got paid the same thing. There also is a misalignment of interests on the compensation structure. And the misalignment of interest is the higher the sale price, the more commission both agents get. And so even if you're representing the buyer, there's a misalignment because the higher the price, the more commission you got paid. Now, nobody's going to blow a deal, or we know this, over, a couple $1,000s in a purchase price. Nonetheless, there's not an alignment. And the Department of Justice doesn't like that. And then there's something called steering, which actually kind of makes sense from a common sense point of view. And steering was, if you're not offered enough commission, you won't show the property. And the department, and they couldn't prove this, but that's what they're saying, right? That if you put, and that they actually said that sometimes agents of the seller would say to the seller, to convince the seller to offer that buy side commission at a higher amount, is if you don't offer enough, other agents aren't going to show it. And if they don't show it, you don't get the exposure. Now, we already said you didn't really need the exposure in the market that we've been living in the last couple of years, right? All you had to do is a couple people hear about it, spreads, everybody's looking for, it's really a seller's market. And even in a seller's market, commission on the buy side did not come down. And that's not what the Department of Justice and the FTC was looking for. So that's kind of it in a nutshell. And if you're practicing today, I think you continue to practice the way you're practicing. You make sure you disclose to sellers that they don't have to pay commissions. You give them all of the reasons why it's important, but you don't say that if you don't offer the commission, nobody's going to show your house, right? Because that plays right into the hands. That's steering. And because if in fact it's true on the buy side, it's steering. And that's part of this whole case, all of these cases as well. So it is big news. The money is big money. I think it has the potential to dramatically change the way people offer compensation in real estate transactions. There will be ways developed to transact around this, I believe. People say, well, the buyers aren't going to have the money to put the money up. I think so. No, the lenders aren't going to allow it to be financed on the buy side. I think that the lending world is going to play. They're in this with everybody. See, lenders want to make loans, and the secondary money market wants to be able to buy those loans and package those loans and sell those loans to pension funds and mortgage-backed securities. And all this stuff isn't going away. We have something called the housing finance industry. It's what makes people's ability to buy properties, makes it a possibility. That's not going away. And if the compensation vehicle of MLS changes, it's not going to kill the housing market. It's going to force change in the housing market. And so you just want to be aware of it. You want to be able to talk about it. It's not coming tomorrow, but there are things you can do in the meantime. And like I said, it's learning how to and asking for the buyer broker contracts. So if you're not familiar with them, if you're in California, CAR creates a buyer broker contract. And so you want to make sure that you've got copies of that, you understand it, you get people to sign it. Now, when's the best time to get a buyer broker contract signed? For me, it's always been, I was telling Allison, when they passed the agency disclosure law in 1988, I thought that was the perfect time to get buyer broker contracts. I thought it was so important that I created a tape set called How to List Buyers. You remember tapes? A tape set. Hey, cassettes. how to list buyers, because I thought this agency disclosure thing is going to get people. Here's an opportunity to get a buyer contract signed. You make your agency disclosure, you explain fiduciary duties, you explain how important it is to have a fiduciary representing you in a real estate transaction, and then you say, if you'd like to hire me to be your fiduciary, here's the way we do it. I use a buyer broker contract. Here's all the benefits of a buyer broker contract. Now, what agents would say was, if Jim Harrison doesn't use a buyer broker contract, I don't want to ask for one, because they're not going to want to deal with me, because I'm going to make them sign a contract and all the other agents aren't making them sign a buyer broker contract. So everybody was afraid. And so most people, now some states have made it mandatory, but most haven't. And so learn about the buyer broker contract. Learn how to present that buyer broker contract. Do it as soon as you can when you're working with somebody. And if you're working on the sell side, make sure that you document, that you explain to the seller that they don't have to offer compensation. That doesn't mean you can't tell them why it's important to offer compensation, but you got to make sure that they understand that they don't have to, and you'll limit your liability moving forward if you do that. So that's kind of my summary of all of this. And Allison, do we have any questions we need to answer?
We do. There's a bunch of questions in the chat here. I don't know if you want to buzz through them, or I can start.
Why don't you just look at it?
Okay, we've got one here from Michaela. I have learned that commission is being paid to the listing agent. Seller and listing agent negotiate the fee. The listing agent then pays X amount to the buyer's agent or brokerage. So that part is actually between the agents, not the client. Did I understand that wrong, or over all those years, or is that fact being overlooked in the lawsuit?
No, so here's the deal. It doesn't matter what I think, and it doesn't matter what you think, right? The fact is that what the court has decided is that the structure of the MLS keeps commissions artificially high. And so, yeah, from a technical perspective, what happens is the seller, and actually it all happens through the transaction, and it all happens in California through escrow, right? Is that the contract is with the seller and the listing agent. But, we even called the buyer's agent the selling agent for years, didn't we? Which really confused matters.
Yeah.
And that artificially keeps that up. And yes, the compensation then flows into escrow, and the buy side never even goes into the hands of the listing agent. And it's the transaction. And technically it's because the seller has authorized the listing agent to pay a buyer broker. But the argument is the seller didn't know they didn't have to. Oh, yes, they did. No, they didn't. They're saying they didn't know, because if they'd have known in the marketplace where everything was selling, I mean, if it were me and I really knew this and I really understood this as a seller, I might have said to my listing agent, I don't have to pay the buyer's agent. Why don't we wait 30 days then? Why don't we put it on the market and you go ahead and market it and advertise it? And if I don't have to pay a buyer's agent, I'll save 30 grand or whatever it is I'll save. And so let's try that. But that didn't happen, because the seller, according to the case, right? I'm just giving you the case, didn't really understand that. So it doesn't matter that, yeah, in the contract, they stated that the listing agent then is authorized to do this. They really didn't understand it. And so that's uninformed consent. And so that's why it's so important you make your sellers understand, but then you tell them the benefits of exposing the property to a broad audience. And however your broker instructs you to inform the seller. So you're right that technically the offer of compensation is negotiated right in our contract, where we say, okay, you're going to pay me X% and you allow me to offer this. But the case is that, in all these cases, that the sellers really didn't understand that. And then people say, well, the people want to argue with us. They want to argue. They say, well, what do you mean they didn't understand? Yeah, they understand. It's like, it's futile for us to argue that point. right? That's not what's going on here. This is a battle that goes back to pre-1983. This is a battle where we step on our toes all the time. We actually hear people saying, look, Northwest MLS last October changed their compensation model to 0. And when they changed it to 0, people are still getting paid the same commission. So this won't change. Have you heard that argument? This won't change anything. Well, that's actually more evidence for the Department of Justice that the system isn't working right. Because if sellers really understood those commissions, and in particular with the advent of the internet. Now, I don't know about you, but I was around when the World Wide Web first became prevalent. Matter of fact, it was one of my jobs was to teach people about using the World Wide Web in real estate and teaching them how to use email. And everybody thought, back when I sold real estate, we all called ourselves real estate morticians, right? Throw them in the back seat, drive them around till they're dead. And we would take people out and show them, and they don't do it. The people know a lot about it before they actually. So people thought commissions would probably start to change with the internet. Guess what? They didn't. Now, I'm not saying that they should have. That's what other people were saying. And that's part of this whole case, right? And it's a big case, and it goes way beyond the civil litigation. There's major dispute between the National Association of Realtors and the Department of Justice. Has been going on for a long time. So the person who asked that question, you're right. Technically, you're absolutely right. But that's the logic behind all this, right? It doesn't matter.
There were a couple more questions, sort of a two-parter here. How many of the jurors ever owned homes? And in Australia, I think most properties are sold through auctions.
That's probably true. Doesn't matter. Right? So it's probably true. And in Australia, it's auctions, and the average commissions in I just looked at a slide the other day. I could probably pull in the United Kingdom. It's like 1.5%, right? They're different. It doesn't matter, because what's being attacked is the compensation vehicle of MLS here in this country. Whatever the Department of Justice or the courts use to make their decisions, that's all well and good. So the auction thing, you're probably right. They're done by auctions. True, probably right, in Australia. What was the other part of that question?
Oh, how many of the jurors were homeowners?
Yeah, I don't know, but I would bet probably all of them were. Matter of fact, if there's some of you read some of the stuff, is that the jurors actually, and the plaintiffs actually had nothing but good things to say about their realtors who represented them in transactions. So it's not a personal thing at all. And again, it was decided per se, right? So the NAR didn't even get to make the case as to why MLS is a good thing. All of the pro-consumer things that happen, the marketplace that it creates, right? It was not relevant to the decision, which is going to be part of the appeal. And whether or not successful, we'll all see. In the meantime, it doesn't affect your daily practice, except that you want to make sure that the things you can do, you do, which is start to use buyer contracts, make sure the seller understands the compensation structure. You might even talk to your broker first, but you might even get them to sign something that says they understand it. Because how deep this goes, nobody really can say at this point in time. But you don't want it to stop you from conducting business the way you conduct business. You want to be able to continue to list and sell real estate. And there's always going to be a need to list and sell real estate. So we're going to figure this out, right? There are going to be ways to do this. It's a giant industry. But right now, people are kind of on edge because the decisions are so huge. And, they're going back to this. Where did this 1.5 billion? They just took the buy side commissions. They didn't even assign any. They didn't say, well, the buy side commission is X%. So 2/3 of that's proper and 1/3 of it's not. They just said there's no value on the buy side. And so that's how they calculated that. So, that's all going to be hopefully renegotiated when NAR appeals this. We'll see. And on this judgment right now isn't even final yet, right? It's still, the judge still has to approve this. We'll see what happens in the next month or so.
Another question is, do you think a new seller's disclosure will be developed?
You mean the transfer disclosure statement or an agency disclosure? Probably an agency disclosure. Maybe that might be a place to put it, in that agency disclosure on the seller side, right? I don't think it'll affect the transfer disclosure statement. It could. I mean, that could be a place to put it. You know, at CAR, we've got a great the form committee at CAR, just so much great talent there. Those people that get together, that talk about this, that are practicing brokers, that come up with these great forms that we have to use, which, by the way, is a great argument for being a realtor. So everybody's going to abandon the real estate industry. Well, if you have to be a realtor to use the forms, then maybe you won't abandon the realtor organization because you want access to the forms.
Another question here is, so if I have a seller and she's willing to give me X% and decides to only offer the buyer's agent less, is that okay?
Yes, that's okay. Matter of fact, that's the preference according to the way this last case came out and the Department of Justice. That's what they would take out less, something different.
Mm-hmm.
Right? Because it would depend on the market, wouldn't it? Theoretically, if it's a seller's market, maybe it would be less, but if it's not, maybe it would be more. I mean, I remember selling real estate where in the 80s, where I offered more to the agent that brought in the buyer.
I've seen it all. I've got to say, on the escrow side, where the listing agent will take a reduced commission for whatever reason, their friends are helping them out, family or whatever, I don't know, and offer more on the other side, or other times where it's just a flat fee of hardly their gas to get there, to all kinds of percentages. I mean, we look at the RPAs and see all kinds of different compensation models in there.
Yep, for sure. So could they offer more or less? Yep.
Let's see here. All right, just sort of a follow-up. There was a comment about not using specific percentages since we're in an antitrust discussion, which is a good point. And here's another comment.
That's why I always use 4 or 5 or whatever that might be. But I think that's it's an interesting point. As real estate licensees, we're always ultra concerned about antitrust, aren't we? Well, we should be. That's what this is. This is antitrust. And this is antitrust on a huge scale. And so as concerned as we are about not talking about commissions, although if you go on social media, people talk about it all the time. It's amazing. We should be as concerned here, and we should want to know and understand these cases, and we should want to be able to articulate these cases to consumers.
And there's one other comment here. The sticking point seems to be the following. How does one explain to a seller that if they don't offer buyer agent compensation, but that if they don't, they'll get less traffic and fewer offers? Seems like that takes us back to the very crux of antitrust, doesn't it?
Yeah, well, the interesting thing is that's the thing you can't say, right? So if you're working with a buyer, you can't use as your criteria for showing the amount of the commission, which is kind of a nuts kind of thing anyway, because FSBOs offer no commissions, right? Are you required to show all FSBOs? I mean, if you took it to the extreme, and so what the hard, you're right, the hard point to get across is it might be almost human nature, although they're not supposed to steer based on the amount of commission that might have, but you certainly can't use that as an argument for offering commission on the buy side, right? That's part of what they're claiming. So if you can't, you've got to come up with what are the other reasons to offer that commission. And I don't think people it'd be great to sit down and have a bottle of wine or whatever you're going to do to, and come up with all of the great value propositions. Now, there are a lot of them. If you think about it, somebody who works on the buy side, it's not easy to buy a house. There's all kinds of forms that need to be signed. It's complex. And so somebody to qualify, to find the right buyer, to pre-qualify the buyer, to do all the things that need to be done on the buy side, don't sell that short. And you need somebody who represents the buyer to do that. You want to make sure that whoever's on the other side has got a representative, because guess what? If they don't, that means that your agent's probably going to act as a dual agent. And as a dual agent, that's a limited sort of agency. And then also remember that you're responsible for the acts of your agent when performed within the scope of authority. So now you're going to be responsible for what your agent talks to and says to the buyer's agent. Right? So there's great value in an agent representing the buyer. I'd sit down and make a list up of all the things that you do when you represent a buyer in a real estate transaction. Here's why you want to encourage somebody to represent the buyer, because here's all the things they're going to do for the buyer. But it can't be, you can't say, well, you got to do it because you won't get as many showings if you offer less. That you don't want to do.
I wonder if the attorneys representing NAR and the brokerages actually did that exercise you just talked about.
I don't know, but I will say this about NAR, and I've had a lot of experience with NAR, and I'm a realtor emeritus, which means I've been a realtor for over 40 years. And I believe in many of the good things, and I don't agree with NAR all the time, but I think it's a great organization. And I was involved with NAR in the 2008 litigation with the Department of Justice. You probably don't remember that. It had to do with virtual office websites and the display of data. And I met with the NAR attorneys, and I know NAR hires the best legal counsel that's available, because NAR's got this duty to everybody to do that. So I don't doubt that they put forward what they believe to be their best foot. And I know they're hiring, now appeals are different, right? So the people who are really good at appeals are different law firms, different attorneys, and are good at the basic level, right? So the people that they've gotten, I don't know who they are, but I'm confident that they did their homework, that they hired the best people that they could hire, that they get the best experts that they can get. And it's just unfortunate the way it turned out. We can all be, Monday morning quarterbacks on this, but it was in NAR's best interest and all of the members' best interest to do the best job they could. And I believe that's what they attempted to do. And I also read that the judge used to be a class action attorney, which is kind of interesting. So there's no telling why and how these things end up the way they do. But remember this is not a 3-year-old argument. This goes back decades. And read the FTC report in 1983 around the real estate industry. And it goes back even further than that. And look at the Consumer Federation of America. Go look at the Consumer Federation of America. Has been after NAR and organized real estate as long as I can remember. And when they write about this case and you read what they write about it, it's amazing, because they have a completely different perspective. And that's part of what we're up against. And but again, I think it's important for you to know about it, to be able to talk about it, to not worry about it, to do the things that you can do to continue to build and enhance your business. People are always going to want to buy and sell real estate, and it's going to change. I'm looking at brand new compensation models that are amazing to me, that I think are incredible, make a lot of sense. Technology allows for things to happen today that couldn't happen 10 years ago. Just like, Uber. It's kind of interesting. The way that you can call a ride today. You couldn't do it before there was the technology. And now you can. And Uber didn't displace all of the taxis. And so we're going to find new ways, new tools, new compensation vehicles, and it's not going to displace necessarily the way we do things. Now, some of the things are going to change for sure. We call that a paradigm shift. You've heard that word, paradigm. Paradigm shift is not just a change. It's a fundamental change. A fundamental change. And that's an important point. And so we are on the verge of a paradigm shift, a fundamental change in the way we do business. And so there's two questions that I think you need to ask yourself. And as you come up with answers, it's going to define your future for you. And the first question is what's currently possible. And if it were impossible, it would fundamentally change the way you do business. What's currently possible, and if it were impossible, it would fundamentally change the way you do business. What's currently possible? Sellers paying compensation to brokers on the buy side. What if that were impossible? Would that fundamentally change the way you sell real estate? It would. And so look at then how would you do real estate? You have to figure that out. The other side to that question is what's currently impossible. And if it were possible, it would fundamentally change the way you list and sell real estate. And those are questions you should be thinking about all the time now, because we are going through a period where, before when people talked about paradigm shifts, they were really talking about change. When people talk about paradigm shifts today, we're really talking about paradigm shifts, fundamental changes to the way you do business. And it's being forced upon us through litigation and regulation. And it's not a new thing. It's been around for a while, like I said, but it's happening. It's very clear, the direction. And if you get out in front of it, and you can, then you're going to succeed through this major transition. Any other questions, Allison?
There's quite a few more questions, actually, and I know we've hit our hour. So I don't know if you want to address a couple of them here. I'm trying to see if I can sort of even combine some of them. A couple of them are talking about, is it possible to do a two-tiered commission structure? If the seller chooses a buyer who doesn't have an agent, which kind of ties into another question about, would there be different compensation for the listing agent if the buyer doesn't have an agent, or if the buyer's writing their own contract? What kind of implications? I mean, basically, it's like you've got one agent, like you were talking about before, doing dual agency, but their loyalty is really going to be the seller that they signed the contract with, that they're representing. And that makes me even wonder what kind of proper representation is there for a buyer if they don't have an agent coming in looking out for their best interest. What does that open up for you?
So it's kind of interesting, because if you're a dual agent, you owe both the buyer. It doesn't matter who's paying the commission, right? Because the payment does not designate agency. So you got the same fiduciary duty to both sides. It could go. So here's a workable model. People say it'll never go back to it, but a workable model is to go back to sub-agency. So what if the MLS became a sub-agency model where everybody represented the seller? And if you wanted to represent buyers, you refute the unilateral offer of sub-agency, would have to be documented. I don't want any compensation from the seller. I'm going to get my compensation from the buyer. The buyer is going to write in the contract. It's actually going to be contractual between the buyer and the seller, that the seller pays the commission to the buyer broker. I mean, that could happen. A lot of things can happen. Now we go back to asking yourself those two paradigm shift questions, and then coming up with answers and talking about them, amongst your friends and family. And there'll be new ways, or maybe even old ways to do things as we move into the next era of buying and selling real estate. And it's something else. A lot of this is accentuated because of the extreme seller's market that we've had. Right? Go back to a more normal market, that might change things.
Oh, sorry, I was typing a response in the chat and I thought I muted myself. So I apologize for the click, click, click that you heard there. Well, Saul, I want to thank you very much. There are more questions. I don't know if you want to stay on and address any of them, or maybe we have a part 2 at some point.
We can do it. We can do whatever you like. If people want to reach me, send your question to me. You can. My email address is saul@bettercallsaul.realtor. Saul@bettercallsaul.realtor, not .com, .realtor.
Awesome, thank you. There actually was one that that really piqued my interest because I'd like to hear your answer to it. Why can attorneys all charge a 30% contingency? Isn't that antitrust or collusion?
Well, I'll tell you why, because nobody's suing them. You see, that's all. I agree, but me agreeing doesn't have anything to do with this case, and nobody's suing the attorneys for this. And yes, they do. They all charge pretty much within the same range. Try and get an attorney to take less when they charge based on contingency, which is really what real estate is, right? It's contingency compensation. If you don't close, you don't get paid. Attorneys do it. Theirs is a fixed amount. Nobody questions that. I agree. It doesn't matter. That's not who's on trial here. And so I agree with you. So I'll support you if you want to litigate. I won't pay you, but if you want to litigate against the legal profession, you have my support. It's a great point. It's just not relevant.
I think a lot of consumers would like it. There aren't too many attorneys who want to sue one another, but
that's the problem. Right?
But I think a lot of consumers would be behind that. I hear a lot more attorney jokes than realtor jokes, I must say.
The judges are all ex-attorneys. I mean, what are your chances, right?
Jury.
Yeah, well, then it's down to jury instructions, right? And the judges make the jury instructions.
That's true.
So anyway,
well, if anyone has a burning question, feel free to unmute yourself and ask right now. Otherwise, we'll give this a wrap. I want to thank you so much, Saul, for joining us today and sharing your insights, and everybody who was involved in asking questions and participating today. We really appreciate it. Those who want to stay informed about my Marketing Mondays, I'll add you to my mailing list, and we will continue to bring current, timely topics forward for everyone to weigh in on. So thank you, Saul. I'm Allie Jackson with Centennial Escrow. Have a great week, everyone, and blessed Thanksgiving.
Thanks, Saul. Thanks, Allie.
Appreciate it. Happy Thanksgiving, everyone.
Thank you.